Now, the SACP, ANC, as well as COSATU were livid at the decision to release Chris Hani's killer, Janusz Walus, on parole. But is there any legal recourse or challenge they can mount? Could they even take the ConCourt's decision on review? Well, let's find out more from legal analyst Mpumelelo Zikalala. Mpumelelo, good morning, and thank you very much for your time. We all know this judgment is probably by far the most emotive. The Tripartite Alliance, as you would have heard there, and ordinary citizens will be picketing tomorrow outside the ConCourt. But beyond this, they've revealed that they're exploring their legal options. Now, when we look at that unanimous judgment, they made reference to the Justice Minister's own considerations in paragraph 66, where the minister listed Walus's commendable behavior, his adjustment in prison. He also speaks of the remorse on the part of the applicant. I mean, when you look at all of that, even the fact that he says the applicant doesn't necessarily pose a risk to reoffend, was this not a matter where the court clearly was dealing with what it had in front of it?
Yes, it was. But you must also come back and ask yourself, what is the court supposed to do? Or come back to the doctrine of separation of powers. The court is not there to decide whether someone should be granted parole or not. However, the court should decide whether is the decision okay, and then say if the decision is not okay, Minister, go back and review this matter again. Look at it with fresh eyes after the pronouncement that we have made, and on that basis, maybe you can come to a different conclusion. The doctrine of separation of powers is very important in this case. You just remember, you can't be a referee and a player in every single thing that you do, and our courts are simply there to assess whether the conduct is okay or not, and not to state remedies which, at the end of the day, are going to end up taking the powers of the decision maker. Another important fact that you must look at is that the minister would have been in a position where he's provided with the complete proper record, be able to ask probing questions either to the person with the applicant or to the other related stakeholders party, in which a court cannot do that. A court is simply bound by the affidavits which it has in front of it and nothing more. So on that basis, which is why our courts are not designed to be decision makers in terms of deciding these type of parole applications. However, it is the minister who's going to take all the relevant factors into consideration and then come back with a decision, which is why it was a bit puzzling. Why would a constitutional court or the presiding officer then want to take on a decision and pronounce on a certain matter when all the facts are not in front of them at the end?
Because they not only set aside, but they went on to actually insert their own orders there. They replaced those and inserted their own, that he will be released within 10 days. But if we look at a lower court, we follow this matter, the lower courts had actually ordered that the minister look at this matter with fresh eyes, and then he came back and still rejected. So if we look at the process before, that was the role that the court had played, where they had separated powers. So was it not that they were now well within their right, taking into account that they had, at a lower court, given him the option to relook this parole, and when he relooked it, he still rejected?
Most importantly, we look at the record which is supposed to be looked at. So, do I have all the relevant information that can enable me as a decision maker to take the appropriate decision? If the answer to that is no, and that particular record which is in front of me needs more probing, then I cannot be in a position to take that decision at the end of the day. A perfect example of this would be to say the consideration of the Hani family, for example. What sort of questions and submissions did they make? Did they provide further clarification on those particular submissions, or did the court simply say, we're simply going to accept whatever that has been written and considered by the minister, and it's going to end there? Those are the type of questions and other probing that would have taken place in that particular sense. Even if the minister could be seen as not participating or doing their job, at the end of the day, the court cannot step into the shoes of the minister and decide for the minister. The court is not designed for that. So at the end of the day, you send back the decision and you simply say, go and look at this matter with fresh eyes and come back, and maybe we're going to get a different decision from what you had earlier. But what I'm going to look at is the methodology that you have used in assessing this matter. Is it correct or not? That's where I'm going to start and end in my own analysis and the presiding over this particular matter. To step into the shoes of the minister and decide for the minister, that's where you are going to go wrong, and they are sort of trampling and sort of belittling the doctrine of separation of powers, which both these entities are not supposed to step on each other's shoes. However, they're meant to be a big brother type of situation at the end of the day, take into account whether someone, are they complying with the law as it is written? If not, then order them to go back and look into the matter.
So could these be grounds now for a review or rescission in this instance, if you are of the view that in this case the court would have misdirected itself or basically violated the doctrine of the separation of powers? Do they have the option to review this matter?
Not a review as such, but a variation in which they are going to say, we are not disputing the whole judgment or part of the judgment. What you are saying is that in your deciding that this particular matter was not decided in a proper matter, the remedy that you have prescribed is not a remedy which is proper in law or which is in line with our legal principles. What you ought to have said was that this decision must go back to the minister, and the minister must then look at this particular application again with all the factors that you would have highlighted or recommended or ordered that they be taken into account. However, the final person who's going to press the green button in terms of the release or not releasing Mr. Janusz Walus is supposed to be the minister, not somebody else. So as the court, can you re-look at this particular application based on the principles in which we are telling you and the danger that is going to pose on all further matters that may come after this one? Because if you do this, you are basically saying that you are basing your decision on a record that may be incomplete, because we do not know what you looked at when this particular matter was in front of you, the number of affidavits and the factors that were included in there. Did you provide a thorough sort of checklist which is prescribed by the Correctional Services Act? Did you have information and individuals that were supposed to come in and provide you with interviews and the minutes which are required so that you are able to take this particular decision? It's okay if you pronounce that the decision to deny Mr. Janusz Walus medical parole is wrong. However, don't step into the shoes of the minister. Send the matter back so that at the end of the day you are able to come back to a conclusion. Maybe let me make another example which is maybe similar to this one. Whenever the court is adjudicating as who's supposed to, whether the tender processes were okay or not, once the court pronounces on that particular decision, it doesn't say that person B must get the tender. It says the decision is invalid and the matter must go back to the decision authority so that that particular authority can then come back and make the appropriate one. It's what should have happened in this case.
Similar to the most prominent case being that of the former President Jacob Zuma, where most people would be familiar with the orders there, that it must go back to the commissioner to make a final determination as to whether he factors the time he spent outside. Is it similar in that instance?
It's similar in the instance that you then have to say, let us look at, I'm not going to be the decision maker at the end of the day, but that one, again, is a bit flawed, because if you look at the technicalities and the implications of such, then you're not going to get a decision which is just. And at the end of the day, Mr. Zuma is part of a litigant who was there at court, made submissions and said, can you please reconsider whether my rights are going to be protected in this particular manner? The court cannot force the commissioner to do something which is against the law. But here, the court can force the minister to go back and look at the provisions and the facts which are in front of him, which that is something which is inside the four boundaries of the Correctional Services Act, and the minister can do at the end of the day.
So in closing, you're saying the legal terminology is that at this point, they can apply for a variation of the judgment or variation of the order. Which one is it?
It's a variation of the order, of saying that this is what can be ordered, so that that particular variation or the order in which they'll be seeking would be in line with the doctrine of separation of powers.